Welcome back, everyone. So, we're going to do a little bit of a clarification here about my last video, and I hope that somehow, some way, what I'm about to say here will make sense to you, and you'll be able to put into context exactly what I was trying to say. And even if you don't believe me, I'm going to put up here on the screen the federal statute. All right, the section. You can go look it up yourself online, or since so many of you think that I'm wrong and that Scott Reich is right, which I've watched every one of his videos and I'm a subscriber, I haven't heard him say anything about this at all. So I think some of you are just trying to blow smoke up my butt. But hey, come on. Let's get real here for a minute. I have the same abilities as you. And in a lot of cases, I have more abilities than you. I'm not trolling people on the internet daily to make rude comments because I think it's funny. So here's the section. You should see it on your screen right now. Section H, as in Henry, 553.11, limitations on inmate property. This is a federal law. Federal, okay? Actual section number 64 FR 36753 passed and went into effect July 7th, 1999. This law went into effect for the very first time in 1907. Then in 1933 it was ratified again. 1952 was ratified. 1968, 1980, 1990, and 1999. Yes, what does the law actually say? Well, let me tell you. Got it right here. An inmate may possess photographs subject to limitations of photography, as long as they are not detrimental to personal safety or security or to the good of the institution. Absolutely nothing in the actual federal statute says that the pictures that they have may not be of victims, must be family only. Does not say that anywhere. They can have pictures of whatever they want. Now, there are restrictions. Obviously, they cannot have, pornography, and they cannot have gangs pictures or gang signs or acts depicting violence, because these would fall underneath the stipulation detrimental to personal safety or security. It would fall into that section. So, can we pass a federal law that would restrict the rights of one individual over the thousands of other prisoners in the country because we want to? The answer is no, you can't do that. That's not how the United States government works. If you don't like how the government works, I would highly suggest that you move to Canada or to New Zealand or Australia or someplace else and see if you like their laws even better. Because this is America and this is what we do. We pass laws that treat each and every one of us with the same due process and laws. Laws that govern all of us, not just one of us, not 10 of us over here, but all of us. We all must live within the same parameters, laws, and restrictions. And because you're not looking at the bigger picture. Let me explain and give you the bigger picture. There are currently where I came from. I saw the comments. Yeah, 873 comments saying that I was wrong and that there was no way that this was possible. When did this become law? Well, I read you the actual section of when it became law the first time. It became law in 1907, 1933, 1952, 1968, 1980, 1990, and 1999. This is federal, United States of America, federal law. This does not even include the laws that are on the book for international and dual citizenship. Well, Christopher Watts is not a dual citizen, and he is not a prisoner of war or any of the other ones, so I don't have to bother going through and read you all of those. But I did read you the section, and you're more than happy to look it up. All right? So, bigger context. Look at the bigger picture. When it comes to people who kill their children, it is predominantly, again, family annihilators are more men than they are women. But when it comes to parents who kill their children who have been convicted, it has been more men than women. But let's not forget the women and the high-profile cases there. How about Susan Smith? Let's not forget her. She said that she was carjacked by an African-American man at an intersection in the middle of nowhere, and he stole the car with her 2 kids in it, and her kids, for 9 days, she pleaded to America and to the world for her safe return to her 2 little babies who were strapped in their car seats, when in all actuality, she drove her car into a lake and drowned both of them. Why'd she do it? Because she was having an affair and she wanted to continue a relationship with a single wealthy businessman in town. And he said, I don't want children. So she got rid of the problem. She got rid of her children. How about Darlie Rotier? She stabbed and killed both of her kids in her living room. Was it 50 times she stabbed both of their boys and watched them bleed out all over her living room? She's on death row in Texas. Why do I mention these two? Because both of them have pictures of their children. And not only pictures of them alive, but both of them have pictures of their children when they were dead. Which ones are being more victimized? The pictures of them dead, and that these 2 mothers have, or the picture of Christopher Watts and his 2 little babies on the front porch of his house? Which one? Are these victims, or are these people victims? The federal law does not stipulate that they have to be only pictures of their family and they can't be their victims. I stand by my word. The petition is pointless. That's not how you change law. I mean, if one of the petitions caught any traction, they got, say, maybe 7 or 8 million out of 131 million people signed it. Maybe it would gain enough attention that someone would start holding meetings and we'd waste a whole bunch of tax dollars. And then, it would go up onto the floor for voting, but they wouldn't vote on it because, they want some kind of pork belly, well, build me some bridges in my state and I'll vote on your, take away pictures from an inmate. But I want, this plant built in my state for my constituents. And if you could grease the wheel with a little bit of free dinners and some cocktails. That's how our politicians in the entire system works. It's corrupt. And you'd never get it to a vote unless you get real change. And change.org hasn't done much of anything except for on the state level. And on a state level, if they were to change the actual law and take the photographs from Christopher Watts and all the inmates in the state of Wisconsin, it wouldn't even stand long enough for the first legal challenge. It would be eliminated. The law wouldn't even make it to the books. The ink wouldn't even be dried on the printing of it before it would be struck down. It wouldn't last. Are you going to then pass 50 more of them? I'm not even talking, again, I'm not talking about international law, that laws that we've agreed to as a country, how we're going to treat prisoners here so our prisoners abroad are treated the same way. You can't just make a law to punish one guy. Yeah, I know it feels wrong, but in the grander, view of it all, why are you even worried about that? How can you possibly be victimizing someone who's already dead with a photograph? If he was sharing the photograph or selling copies of it or printing it on t-shirts or something like that, yeah, he could be victimizing their memory. But there's no way he's sharing that photo with anybody else. And it's the absurdity of the fact that, of him, people saying that he is sharing that photo with pedophiles in his prison. Man, no, no, that'd be simple as I can say. And in case you want other examples of other people who've killed their families here in America, where they've had photographs of their families, Christian Longo out in Oregon has pictures of his family and his dead children. And so does James Rupert and Donald Simmons, to name a couple more. Uh, we, yeah, I could go on and on and on. I mean, it's been on the books for so long since we've had photography. People have been able to have, these prisoners have been able to have photographs of their families. Keep it real, everyone.